This is Invisible Inc., the podcast for under-resourced women entrepreneurs. And I'm your host, Shubha Chakravarti, founder of Achieve. In this podcast, I talk to women entrepreneurs at every stage of their journey about the challenges, the highs, the lows, and what they've learned along the way. We'll also hear from experts who share valuable tips on how to succeed the smart way. Let's jump in. Do you hold any of these beliefs? That building a bankable brand is all about smart marketing? That legalese is for later, when you're bigger and making lots of money? That once you snag the domain name of your choice, your brand is safe? If you do, you just might be setting yourself up for a lot of pain later. In today's episode, Shireen Smith, author of Brand Tuned and IP and branding expert, reveals common myths about branding and law that trip up many new and small business entrepreneurs, and provides immediately actionable tips on how to create, build, and protect a high-value brand for your business for the long haul. Now here's Shireen. Thank you, Shireen, for joining us today. You're the author of this book, Brand Tuned, which I'm a huge fan of. I discovered accidentally and it captivated me. Tell us a little bit. It's an unusual space. How did you come to do with the work you're doing?
Thanks for having me here. I'm a lawyer by background, an intellectual property lawyer, and I was seeing a number of similar problems that business owners had around branding, which is that they were totally unaware of intellectual property and the impact it has on their business. And at the same time, I knew many designers and marketers who are not trained in brand, in law at all, in IP. And yet everything you're doing when you create a brand involves creating intellectual property. So I thought, well, I need to really understand what branding is so I can explain to designers and marketers where they need to really focus in order to better support business owners. Because if business owners are going direct to branding professionals, they're not getting any IP input, and IP is left till last. And actually, it needs to be considered first before you create. Because I think branding is the sort of area where you need intellectual property, marketing, and design understanding to really bring a holistic set of skills to the table.
I'm sure you've worked with a lot of entrepreneurs, and I'm sure a lot of them have missed the branding and the IP aspect. Do you have a story or stories that pop into mind?
Well, there's a story I've got in the book, but one that's quite famous is Scrabulous. So they had created this app to play a Scrabble-like game online, and it had millions of followers on Facebook. When Hasbro found out about them, and because the name is too similar to Scrabble, they got a takedown notice to Facebook, who then pulled the app, and Scrabulous suddenly was no more. Now, that happened because they weren't aware that a name that's too similar to somebody else, who's an existing brand owner, is a problem, to such an extent that they actually went to register their trademark at the USPTO. They did it themselves. And that's what brought them to the attention of Hasbro.
So it sounds like they did that a little too late in the game after they had achieved all this market traction and fame for Scrabulous.
That's right. Yeah, that's often what happens. People think they need to wait until they've got something worth protecting and then they go to protect it. But of course, in their case, it was poor name to be using because they probably had a lot of the success they had because of the name being similar to Scrabble. But if they'd taken some advice before they applied to register that trademark, they might have been able to quietly rebrand and choose a different name. But as it was, they lost the sort of market leading opportunity that they'd uncovered, and Zynga entered the market with words with friends. So Scrabulous still exists. I don't know what they're called, but they just completely lost that momentum that they'd gained by being the first to market and very successful.
So it sounds like a rose by some other name wouldn't smell as sweet, at least in the branding business.
Yes, so you need to be very careful not to choose names that are similar to industry. Other people who are advising you may know about Scrabble, they may know about Apple, but if you come from an industry where you know the market leader and you choose a name similar to theirs that other people don't know, then nobody can even warn you that, hey, you're using a name that's too similar to this famous brand. I knew a potential client, they were ringing round to get help. They had had their domains confiscated in a domain dispute because the name they'd chosen was similar to the market leaders in their industry. And then eventually they lost their domains and had to start again. But they'd spent about $200,000 getting momentum, getting this fantastic website. And all that was gone because the value was in the domain name, which they had brought up in the search engines, and then they lost it because of a trademark issue.
So it sounds like it's not just the mental space you have in your customers' minds, but it's real money that you spend on buying a domain, on search engine marketing. All of that goes away if you're not careful about IP and the brand implications of the name you've chosen. So what's clear now then is that the brand name has a very big intersect with the law and the IP side. So if I'm an entrepreneur starting out, are there like 3, 4, 5 areas that should immediately trigger something that says, hey, IP? What are those areas in your mind?
The name, you definitely need to get a lawyer to search the name for you and give you advice on it. So even if you're going to be registering your own trademark, I think you need a lawyer to actually give you the okay with the name. So that, I would say, is essential to spend money on. And then because everything you do in a business is getting name recognition, you need to make sure you own the name that you're using. It's just taken for granted by people until they lose the name or something happens. But it's one of the most solid issues that you've got to deal with in a business. I often advise people, if they're starting and don't have much money, to use a temporary descriptive name that you can't register as a trademark, because then you avoid all the costs associated with trademarks and legal advice. You can just test your business concept, and if it's successful, then you can go and choose a name and register it as a trademark.
I think those are the two main things that I took away. Is one is make sure that it's your name is a name. Everything starts with a name. And then secondly, if you're not sure and you're starting out, then it's okay to start with a temporary name.
It's a good idea to start with a temporary name. Also, domains and company registration don't give you the rights you need in a name. So it's trademarks that give the rights to a name.
You talked about the name and how important the name is. In the book, you talk about some do's and don'ts about how to name your business and how not to. Would you kind of just give a high level on how to pick the right name for your business?
There's lots of issues around names, quite subtle issues. One is that it shouldn't be too descriptive of the category. So the more distinctive a name you have, that means that it's just a name, like Google is just a name or Zumba is just a name. The easier it's going to be for you to protect your brand, to register your trademark. It's going to be cheaper to do a search in every way. But on the other hand, people tend to want to describe what they're doing so that it has some sort of marketing benefit. And that's where it's more difficult to find an ownable name, or even if you own the name, you get a very narrow scope of protection so that somebody else could use something very similar and you wouldn't be able to stop them. Getting away from this need to describe what you do when you choose a name is so important. Like McDonald's isn't saying Burger King. Burger King tends to be on the descriptive end because it's burger. You can't monopolize a term that others in the industry need to use. So burger can never belong to you. So all you're getting is Burger King. Whereas McDonald's is totally descriptive, distinctive. It's got nothing in it that describes burgers, and therefore they have better brand protection as a result. So Oatly is another example that came up recently. They tried to stop this other company using Pure Oaty as a name. They said it's too similar to Oatly. But Oaty is a generic term, and the law in no part of the world will give you a monopoly over a generic term. So they only managed to get a trademark because they added the L in. And that's, even though they're a famous, well-known brand, who usually, these brands get greater protection than lesser brands. But even despite that, they weren't able to object to somebody calling Pure Oaty. Whereas if it had a distinctive name, say it was Hellmann's, like Hellmann's mayonnaise, if somebody tried to call it Pure Hellmann's, that would be trademark infringement. So it's really important to choose a distinctive name if you can.
Yeah, and on that, of late, I've seen some startups who use a very different spelling for common names. And I myself have a business like that. So, for example, Prosper, let's say it's spelled PROSPRR, or Contently, and names like that, or HubSpot. Like, what's your take on things that could refer to a generic name but are spelled differently enough that you can argue that it's a brand name? What's the law on that?
The spelling doesn't make a name trademarkable, but they do that in order to be able to get the .com domain. So if Fiverr, I think, is spelt with double R, so that you can get the domain name. But that doesn't make it trademarkable. So whether something's trademarkable or not is not determined by the spelling. It's more what it represents in your category. So if it, for example, if you're a pizza place and you want to call your pizzas Fresh Pizza, that's not going to be trademarkable because other pizza owners might want to call their pizzas Fresh Pizza. But if you are selling umbrellas and you want to call your business Fresh, then it's totally distinctive in umbrellas and you can own it. So there's always this context of whether a name can be used as a trademark in your category. So is it a term that other traders need to use or not? If it is, then it's too descriptive. But if it's not, because who wants to say fresh umbrellas, then that is a totally okay name and you can go ahead and trademark that.
You just brought up a very important concept, which is this concept of category. So it sounds like you need to be very clear what your category is before you go ahead and make a call on your brand name. Can you provide some guidance to a new entrepreneur? How do I come up with the right category? I mean, in some cases, when I'm selling pizza, it's obvious. But are there other subtle guidelines that an entrepreneur can keep in mind as they determine their category?
It depends what your vision for your business is. What services are you going to be offering? What products are you going to be selling? And essentially, that's trademark classes. Their trademarks are registered by reference to goods and services. So you need to know the categories. So if you're selling clothing, for example, and jewelry and umbrellas, footwear, they're all going to be in different categories. So you will need to register in several different classes. So understanding the trademark categories helps in terms of what you're going to be offering. So that's the starting point before you choose any name, is what is your vision for the business. There's some other work you need to do before you even think of naming the business.
Gotcha.
So that you choose a name that's a good one.
So you already started laying out some of the things an entrepreneur needs to keep in mind. What is the name? What is the category? And you also talked about some precursors to the actual brand name, such as the business vision. Can you talk about high level, if I'm starting out, I have this business, what are the things that will feed into the brand, the top 4 or 5 things I need to keep in mind as I go ahead and pick a protectable brand name?
Well, I think the starting point is with yourself. What are you doing? What's your point of view in terms of the service or goods you're going to be offering? What's driven you to create this business? What do you want to do in the world? So your vision, what's driving you? What's your mission? What are your values? These things require quite a lot of introspection. You need to sit down and really give yourself time and space to think them through, because they then help you to decide what positioning you want to adopt in the market. So positioning is called all sorts of different names which mean the same thing. People sometimes call it brand purpose, brand essence, brand promise. They all mean essentially the same thing. A brand, if you think about it, is a set of associations that people have. So when I think Apple, I think design. Maybe you would also think that. Or when I think of Google, I think search, organizing information. So these things that stick in people's minds about a brand that they associate with it, that's their positioning. And really, you need to think in terms of one word. What's one thing you want to represent so that you can ensure that everyone recognizes you by that name, by that thing. So, for example, I want to create some courses on branding for people, branding and IP. And I think what I want is to deliver confidence. So I want people to have more confidence as a result of, say, gaining some more wisdom. But it's essentially, that's the word I've decided is really important, that I'm going to make sure everything I do in the business is designed to generate more confidence in the students. So one aspect is thinking what you want to do. Another aspect is thinking about the market, what is currently on offer in that space that you're entering. For me, what other courses are there on branding and IP, and how can I be different to what they're offering? How can I do things in my way that is going to better meet the needs of a segment of the market that I want to serve? Because you can't serve everyone. Ultimately, you have to choose who is going to be the most ideal target customer for what you want to deliver.
So if I were to synthesize what I just heard, Shireen, it sounds like you start at the context, which is a category. You figure out who your customer is and what they want or what you want them to associate with you. And then,
well, after you've decided what you want to deliver, what's your point of view about your category? I think IP is essential, and this is something that marketers and designers need to know. It's just not something optional because it's so intrinsic to branding when you're creating a brand. So that's my point of view. I feel very strongly about that. That introspection and decision about what is important to you then feeds into what you decide you're going to do. And that's after that you come up with how do you want to position your brand to be known in the market.
Then we come to this concept of, in the early days of a business, it's possible that you're not sure and you pivot to something else. And the pivot may actually change your category. How should an entrepreneur think about branding and IP in those situations where I start out thinking that I want to be an e-commerce business and then I pivot to maybe food service, for example?
Mm-hmm. That's why I think it's really important to have a temporary name and test your concept first for 3-6 months. A lot of people I see have been in business for a year. They might have done their pivoting, because you can only respond to the market once you're actually in the market selling something. So it's a good idea to have a temporary view. It depends on the category and what you're doing. But if it's possible, then take a sort of more temporary approach to your branding, to your name, everything, and test the market for 6 months, a year, learn, and then go and get a wonderful name and branding.
Have you seen in your practice or otherwise examples of good temporary names, or at least guidelines of how you pick one?
As long as you're not going to be stepping on somebody's toes in terms of immediately getting a cease and desist letter from someone, it can almost be anything. I've seen people combine their surnames. So one has a surname beginning, say, with W, and the other has a surname beginning with D, and they've created a word around that, which works for them for a year or so, but once they've got off the ground, they actually decide that wasn't such a good name. Often, names are really difficult to arrive at, so it may be that the name you choose isn't something you actually like that much after you've been in business. So if you don't love the name that you've got, and you've got this temporary approach to things, it can be a name that you later decide you do want to trademark. So you don't have to immediately go and register a trademark. But if it's a name you really like and you think is clever and it's important to you, then I think you should register it as a trademark. But as long as you do some checks to make sure, check on Google, check domain names, check the trademark registers, as long as it doesn't look like you're obviously going to have a problem, then you can get up and away with a temporary name, which you might later decide to keep or you might not.
So you try to get as close as possible to what you want to be, but recognizing that may not be the name you end up with sounds like the approach you're recommending.
It depends so much on the business you're entering. So if you're going to be producing clothes and you're a fashion designer and you're going to put your label in them, you can't just have a temporary name. You can't not have trademarked that, because a product would have to be recalled if there's a problem with it. So you can't take that approach. But if you've got the sort of business where the name is not going to be a disaster if you need to change it, then you could adopt a different approach, which is to either choose a name that you can't even register as a trademark, or choose one you could register, but you just don't register it yet because you're not sure if the business concept is going to be tweaked, or if not. If you've got a platform, for example, you absolutely need to have the name nailed down, because if you're building recognition for a platform, you can't change the name. So much depends on what you're doing as to how important it is to choose your final name and register it as a trademark when you start.
I want to probe a little bit why, I made this mistake myself. A lot of entrepreneurs don't pay attention to IP, thinking I'm too small, it's too soon. Why do you think that is the case? And what can entrepreneurs do to prevent themselves from falling into this error?
Well, I think there's a lot in the world that has changed because of the internet. We've only had the internet for about 20 years now. And so pre-internet, it was actually very expensive to search the trademark registers to register a trademark. You had to go manually to their offices and search. It was just an altogether different experience. Something really only successful businesses could afford, or the big brands. And there weren't so many businesses. You couldn't be found out so easily if you were using a name that was similar to someone else's. You couldn't be copied so easily because people wouldn't know about you. You'd be in a geographic area. So for all those reasons, trademarks and IP was something that, more successful businesses would consider because it was actually quite an expense. Nowadays, with everything being online and you being able to register your own trademark and all these businesses starting up and potential infringement issues, it's a different ballgame, but society hasn't caught up with that yet. So there's still this mentality that, oh, well, if I'm successful, I will protect my IP.
So are there specific types of entrepreneurs that are more at risk or should be thinking about this way ahead of others? And if so, what would those categories be?
I think any business that sells products, physical products, needs to be really careful around IP. With some products, it wouldn't be a good idea to enter the market unless you can get a patent, for example. So potentially you need to keep your idea secret and speak to a lawyer, consider filing a patent before you even start. You certainly need to get the name right, because if you have to change names, then you have to recall all those products.
So our site is dedicated to women entrepreneurs. In your experience, have you seen any differences between how women entrepreneurs approach branding and IP versus their male counterparts?
I thought about this when you asked me this earlier, and what I would notice is that maybe women are not quite so confident. They're not so intending to create something really big or thinking of themselves as having some mega big business, because IP, a lot of it is about your intention. Do you think you're going to be the next Google or the next whatever? So the more you aspire to have a huge business, the more IP is going to matter to you, because essentially that's where the value is going to lie if you create a successful business. I'm not sure whether women are as confident as men in terms of their aspirations for their businesses, whether they're thinking more in terms of lifestyle businesses. I don't know.
For example, my favorite example is lynda.com, which is now LinkedIn Learning, and sold for $1 billion and started off as a lifestyle business. So does that put women at greater risk when in fact their business does become successful and they haven't paid enough attention to the IP issues up front?
I think as long as women are aware of IP, I had one client who didn't know about IP at all. She was searching online for physical property advice, and she suddenly came up against my site with 7 mistakes to avoid with your business. She downloaded the ebook, and on the Monday, she was in my office. She'd made an appointment and wanted to protect her brand, and she's now gone on to register her trademark in a number of countries worldwide. I think if somebody hears about IP and they've got a successful business or are trying to be successful, they usually pay attention. It's just whether they come across IP, that's more the issue.
Hopefully we'll add our might to that awareness. Which brings us to what steps, you talked about your client. What steps should an entrepreneur take in the beginning journey, and how should they go about protecting IP and picking the right name?
I think when you're starting out, the essentials are the name, making sure any designer who's going to design logos for you, that you have an agreement that assigns copyright to you. That's often something that people get wrong, often because actually designers say, well, you will automatically have copyright because you're going to pay for it. But that's not the case. So those are 2 important things. Then if you're going to do some research online to decide what legal agreements you need and you're going to buy templates and things, that's okay. But I would definitely put a budget aside for taking legal advice on your plans and on the name. So that doesn't need to cost a lot, but just go consult a lawyer and say, this is the name I'm using. This is what I think I need to get in place for my business. What do you think? So a lawyer who isn't going to try and sell them doing all the drafting, who will actually say, yes, that sounds sound, I would do that,
These days, there are so many distributed services, so you can commission a logo on Fiverr. A lot of entrepreneurs use these because they keep the startup costs affordable. What are the IP-related risks, and what steps should an entrepreneur take to protect themselves?
Well, I suggest any entrepreneur should have a letter type agreement that covers copyright assignment and confidentiality. Confidentiality, because sometimes if you've got an idea that you can patent, you would lose that possibility if you have revealed it to someone outside the bounds of a confidentiality agreement. So these two are the big risks that I see for business owners. Have they got copyright? Have they lost confidentiality in something they needed to keep confidential? So if you make that part of your process, whether it's on Fiverr, wherever it is, as soon as you get a third party to do any work for you, before they even begin, you get them to sign this letter acknowledging. So it could be a 1-2 page letter just giving you copyright and them agreeing to keep the information they gain confidential. I think that covers off most of the risks most entrepreneurs face.
And that should be a pretty standard template, right?
You could either have one created for you or buy it if you're confident, but have it as a standard process that every time you're about to take on a third party to do even the tiniest thing, you ask them to sign this. Then you know that you're always going to have copyright in what's created for you, and you're protected in terms of confidential information.
That's excellent advice. I will take it myself. Thank you. You talked about finding a lawyer. You talked about getting legal help from the beginning. What kind of budget should an entrepreneur be thinking about for at least the bare minimum protection?
I think the bare minimum that's needed, because you don't know what you don't know. So that's why I say start off doing Google research, deciding what you're going to do, and then go to a lawyer, because you want that security of knowing you've had a name search. It may seem like a lot of money to be spending on name search when you can just search yourself, but actually there are all sorts of complexity in trademarks that people are not aware of, and you want that stamp of approval from a lawyer, really, so that if you do have problems, you've got comeback against someone. So to spend just an hour's advice from a lawyer and a search, I would say maybe $750. I would devote money to that. You can then register your own trademark if you like and do other things, buy templates, do other things yourself, but definitely get one-to-one advice in case there's something you're not aware of, and have a search.
Okay, so now we'll switch gears. You talked a lot about new entrepreneurs, but there are a lot of entrepreneurs who already have existing businesses who may not have thought about IP. So they're here today. They're wondering what they need to do. What advice would you give them to protect their names as they stand today?
I think an existing entrepreneur should have an IP audit just to identify what IP they have in the business and what steps they need to take to correct any problems. Like often it's they won't have copyright in some things. Maybe that's a disaster sometimes, maybe it's not. And you can go back to people who worked for you and get an assignment. So an IP audit, and then obviously registering your name as a trademark. If you've already registered it as a trademark, see whether your business model has expanded so that you might need further classes. Where is your money coming from if you're selling abroad? And there's a country where you're selling a lot, then you absolutely should be registering your trademark in that country to protect your revenues in that country. Then register your logo as a trademark if it's already established and you think you're going to be using it long term. You could also register your tagline if you've got one that's protectable and registrable as a trademark. But essentially, it's trademarks and copyright for most businesses.
Got it. And then you talked about this concept of an IP audit. Can you just expand a little bit? Is that something they can do on their own, or do they need the help of a lawyer as well?
It's really looking at what names are you using in your business? What do you actually have in the business? Like you've got a logo, perhaps. Has anything else been created for you? If you've had software created for you, then who created it? Have you got copyright in that? That could be quite disastrous for a business that's reliant on software that they don't own. But often I would ask to see their legal agreements with any employees and with third parties who have done work for them. And the fact that they don't have agreements in itself tells me that there's a problem, because the default rules under the law in the UK and the USA is that if a third party who is not your employee creates something for you, they will be the owner of the copyright, not you, if there's no legal agreement. So if somebody says they don't have agreements, I automatically know that that's a problem, like their designer created their logo. And that can actually be quite a problem down the line if you ever need to prove your rights in the logo, which happens if there's disputes sometimes. The first thing you need to do is to prove that you've got copyright in your logo. And if you can't do that, it could be a problem. I mean, Innocent had a problem with their logo because they had an agreement with the designers who created their logo that they would give them shares in return for the designers producing the logo. And then the designers, I think, went into administration and some third party bought the assets of the designers. And then this third party wanted to stop Innocent from using the logo unless they got paid quite a lot. And Innocent could have actually had to they would have been in real trouble, except that the court found a way to find in their favor. They construed the agreement with the designers to say that it wasn't conditional. So the fact that they'd never transferred shares didn't mean that they didn't get copyright. Anyway, they were very lucky.
Chances are, don't rely on luck is the lesson I'm learning here. All of this seems to hinge on having a good IP lawyer, which is not the same as a regular attorney you might have for your other business matters. How should you go about finding the right IP attorney? What are some red flags to avoid?
IP is a very, very large subject. You can have patent attorneys with expertise in patents. They're called patent IP attorney lawyers. You might have music lawyers who specialize in copyright. So what you really want is a branding lawyer, somebody who specializes in trademarks. And a lot of general corporate lawyers do IP, but I would think it's better to try and find a specialist trademark person rather than a general corporate lawyer who does IP, because they haven't got the same depth of expertise. But I think in any area, so much depends on the person that you take on. You can ask friends and relatives to guide you, I guess, but I would look on their LinkedIn profiles, see what sort of qualifications they've got. Personally, if I'm going to take someone on, say, to do email marketing for me, if I look on their profile and they've got no training in marketing, I wouldn't use them, even though they might be really, really good, because I think people need both training and experience, and that usually gives the best. So I'd be looking for how much experience have they got in the areas I need help with, and are they actually trained in this area?
Is it reasonable to expect that they would give you a complimentary consultation before you decide? And how long is that typically?
Some lawyers would, if they think that you have potential, if your business seems to have potential down the line. Some automatically will give 20 minutes, because when you're buying a service, you need to know whether there's going to be chemistry, whether the person knows enough about the subject. So most lawyers will give a bit of time, for nothing, in order to onboard a new client.
And are there one or two things you should focus on in those 20 minutes to give you the best information to make that choice?
Well, it depends what is of concern to you. So you could ask whether they have experience with businesses similar to yours, who they generally help, what sort of size client. They'll say everyone, but most people will have a typical. I would say I've got some very big clients who are 350 million turnover businesses, but most of my clients are small businesses. So I think most people have a variety, but what is their typical sort of client base? Because if somebody's dealing with big business all the time, they're not going to know some of the problems that a small business has. And you need somebody that's appropriate to your type of business.
I just want to ask if there are some resources. I love your book, so I'll make the plug for you for Brand Tuned. Love the book. What other resources would you recommend an entrepreneur look up to learn more?
Branding and IP. There aren't actually any books that cover it. This is probably one of the only ones that covers both branding and IP. There's plenty of books on IP and there's plenty of books on branding, but not one that covers both.
Oh, okay. I think you've covered a lot, and I personally feel much more educated as a result of this. What are the things, so having listened to you and having learned all of this, what are the 5 things I should do Monday morning to get a start on IP, a trademark and brand and IP?
Well, have you had your name checked out, the name that you're using? If not, get a search done by a lawyer and then register your trademark. Either do it yourself or get a lawyer. I think in the States, it's about a couple of thousand to have a lawyer register a trademark in maybe up to 3 classes. I don't know. The official fees are quite high, I think in the States, it's like $350 and nearly $300 per class. So a lot of the cost is down to the government fees that are payable. In the UK, I would charge $1,500 for a search and registration of a trademark, but the official fees are much lower here than they are in the States. So register trademark. Are you using a logo that you think is something you're going to stick with long term? If so, I would register that as a trademark. Have you got the logo, the copyright in your logo from your designer? If not, go back and try and get an assignment of the copyright from the designer. And do you have a tagline that can be protected? If so, register it as a trademark. But really, the ultimate thing with brands is, do they know I exist? So it's important to make sure that the market that you are selling to actually know that you even exist before investing too much in IP. So I don't like to give a set rule because so much depends on the business and where you're at and whether you're going to be making changes. I think in the first 5 years, a business will adapt and change, and maybe overprotecting your brand is not such a good idea. So if other people in your industry are using similar colors, maybe you want to stand out by using totally different ones or have a different logo. I think in the first few years, you can make these decisions and changes. So registering is maybe not a good idea because then you've wasted the money. You have to register again. So it depends how happy you are with your business and with your branding.
This has been outstandingly helpful. So thank you very much for taking the time. Thank you for listening to today's episode. Find show notes and more at achieve.co. That's achiiv.co/podcast. Like what you heard? Hit subscribe on Spotify, Apple, or Google Podcast and never miss another episode. Want to help others like you? Leave us a review and tell a friend. See you on the next episode. Now, go achieve.